When they walked me into that courtroom in Chattanooga, I was wearing a shirt my son had picked out for me, and it was 2 sizes too big, and it was buttoned wrong, and that was not an accident. My daughter-in-law looked at me across the aisle and put her hand over her mouth to cover a smile. My son shook his head slowly, the way you do at something you pity. To everybody in that room, I was a confused old widower in a borrowed shirt who had poisoned his wife for the insurance money. And then the judge came in and sat down and looked at the defense table, and I watched every bit of color go out of that woman's face. And she leaned toward her clerk and said something I could not hear, and the clerk shook his head, and Judge Millsap said out loud into a silent room, "Oh my Lord, is that Hollis Barlow?" My name is Hollis Barlow. I am 74 years old. Before I tell you what my son had done to a piece of paper on my wife's kitchen counter, tell me in the comments where you are watching from tonight and what time it is where you are. And hit like and subscribe if somebody has ever decided you were harmless. One honest note before we begin. This story is a work of fiction. The voice you are hearing and the images you are seeing are AI-assisted. Names, places, and events are invented for storytelling. Any resemblance to real people is purely coincidental. But the lessons about family, greed, and quiet strength are very real. Now, let us begin. I need to take you back 14 months to the August my wife died. Junie and I had been married 50 years that spring. She was a school librarian for 31 years at Brainerd, and she had the kind of mind that files things and never loses them. And she had atrial fibrillation, which she had managed for 11 years with a blood thinner and a nuisance of a diet and a great deal of complaining. On a Saturday morning in August, I came in from the tomatoes and she was on the kitchen floor by the sink, and she had been gone about an hour. The medical examiner said a bleed. Given the warfarin and the age and the history, nobody looked twice, and I did not ask them to, because I was 73 years old, and I had just found my wife on a linoleum floor, and I was not capable of asking anybody anything. I want to tell you what I did for a living, because it is the whole hinge of this. I started at 20 on a press in a security printing plant off Rossville Boulevard, running bank drafts and stock certificates and negotiable paper. 22 years of ink and plates and learning what makes a document look like what it claims to be. And in 1993, the State Crime Laboratory hired me into questioned documents, and I did that for 22 more years until I retired in 2015. That is a job most people have never heard of. It is not handwriting analysis the way the television shows it. It is comparing a disputed signature against known writing and deciding whether the same hand made both. It is finding out whether a will was typed on the machine they say it was. It is line quality, pen lifts, tremor, pressure, the order in which strokes were laid down. I testified in 900 and some cases. I wrote the state's evidence handling protocol for questioned documents in 1998, and it is still on the wall in that lab, and nobody in my family ever paid the slightest attention to any of it. To my son Rowan, I was a man who worked at the printing plant, and then worked for the state, and then retired and grew tomatoes. He was born in 1981, and he never once asked me a question about my work, not at 10 and not at 40. And when people asked him what his daddy did, he said he printed money and laughed. I have thought about that a great deal since. He had a father who spent 22 years learning to tell a real signature from a false one, and it never occurred to him that this was a thing worth knowing. And it never occurred to him that this was a thing that could hurt him. It started on the 9th of October with a certified letter I had to sign for at the door. It was from an investigations unit at the life company that carried Junie's policy, and it said that the claim paid to me in November of last year, $2 million and change, was under review for possible material misrepresentation, and that I should not dispose of any documents. I stood in my own doorway and read it 3 times. There was nothing to dispose of. Junie had carried that policy since 1996, and I had never touched it. I called the number on the letter, and a very polite young man told me that they had received information suggesting the beneficiary designation on file had been altered and that I would be contacted. Rowan and Sloan came out to the house that evening, which by itself told me something, because my son had not come out to that house without being asked in 2 years. He sat down in the chair his mother used to sit in, and he had a folder with him. He said, "Dad, I did not want you to hear it from a stranger." And he opened the folder, and he laid 3 things on my coffee table. A change of beneficiary form for Junie's policy, dated 4 days before she died, moving the whole thing from a split between me and Rowan to me alone. A handwritten note in what looked very much like my wife's hand, saying she wanted her husband taken care of. And a receipt from a notary in East Ridge who had apparently witnessed both. He said, "The insurance people showed me these last week, and I have been sick about it." He said, "Dad, I know you have not been yourself since Mama died." He said, "If you did this because you were frightened about money, I understand it, and we can fix it, and nobody has to know." And Sloan sat on the arm of that chair with her hand on his shoulder and said, "Hollis, we just want to protect you." And I sat there and looked at my son telling me I had forged my wife's name. And I want you to understand that my first feeling was not anger. My first feeling was the thing that happens to me when a document is put in front of me, which is that my eyes went to the signature and started working before the rest of me had caught up. Here is what I saw in about 4 seconds, and I have never in my life been able to turn it off. The signature on that beneficiary form was a very good simulation. The letter forms were right. The proportions were right. Whoever made it had studied a lot of Junie's writing. But a simulated signature is drawn, not written, and drawing leaves marks. The line quality was too even, no natural speed variation, no thinning on the upstrokes where a fast writer lightens. There was a pen lift in the middle of the capital J where Junie never lifted in her life. And there was a hesitation blob at the base of the second N, the tiny pooling of ink you get when a pen stops moving while the hand checks the model. That was not my wife's hand. It was somebody's hand copying my wife's hand, and doing it well. And then I looked at the note, and my stomach turned over, because the note was not a simulation of Junie. It was a simulation of me. Not my signature, my printing. The block printing I have used on evidence envelopes and case notes for 40 years. Somebody had written a note in my hand and put it in a folder as a specimen of my wife's, betting that no one would look closely. And they were right. No one had. And whoever did it had my slant, my open lowercase a, and the way I close a 4. That is not something a man learns off a Christmas card. That is somebody who has sat with pages and pages of my writing. I did not say a word of that out loud. I want you to understand why. Because it is the only decision in this whole business I am completely sure about. If I had said, "That signature has a hesitation mark at the base of the second N," I would have told my son and his wife exactly how much trouble they were in, and exactly what I could do. And they would have burned everything and started over better. So instead, I put my hand up to my mouth and let it shake, which took no acting at all, and I said, "I do not understand any of this." I said, "I do not remember signing anything." Rowan and Sloan looked at each other over the top of my head, and something passed between them that I would call relief. They left about 9. I sat in the dark in my own front room until 2 in the morning, going back over 14 months the way I would go back over a case file. and by the time the sun came up, I had a list of things that no longer looked the way they had looked. In November of last year, Rowan had brought me papers to sign about the timber tract, 40 acres on Signal Mountain that had been in Junie's family since 1891, and he had brought them at a bad time and said it was a formality, and I signed them without reading, which is a thing I had never done in my working life, and did the first month I was a widower. In February, he had my mail forwarded to a box at the shipping store on Brainerd Road and told me it was so he could help me with the bills. In April, he changed my phone plan, and there was the thing that had been sitting in the back of my head for 14 months like a splinter you keep meaning to pull. Junie had been unwell for 4 days before she died, and it was not like her. Tired, bruising, a nosebleed on the Wednesday that took 20 minutes to stop. I told her to call the cardiology office, and she said she had, and she said they had adjusted her. And I remember, because I remember paper, that there was a note on the counter under the sugar bowl in her handwriting that said 5 milligrams through Sunday, then back to 2. And I remember thinking that was a large jump, and thinking that doctors know more than tomato farmers. That note went in the trash sometime in the week after the funeral, along with a great deal else, because my sister came and cleaned, and I let her. I went to see Ophelia Rand the next day. Ophelia is 68, and she has been a criminal defense attorney in Hamilton County for 40 years, and she cross-examined me 9 separate times between 1995 and 2012, and she never once got me to bend, and she has never forgiven me for it. She listened to the whole thing with her feet up on a filing cabinet, and at the end she said, "Hollis, you are telling me your son forged your wife's name." And I said, "No, I am telling you my son hired somebody to forge my wife's name, because that work is too good for him, and I am telling you the same person also forged mine." And Ophelia took her feet off the cabinet and said, "All right. Who does that work in this state?"
That is a short list. There are maybe 11 people in Tennessee who can produce a simulation that good, and 9 of them work for the government, and I trained 4 of them. And I sat in Ophelia's office and made myself think about the one name I did not want to think about, which was Curtis Wendt. Curtis came into that laboratory in 1996 at 29 years old with a bachelor's degree and a good eye, and I had him at my elbow for 8 years. I taught that man everything he knows about line quality. He left the state in 2004 and went private, and he has spent 20 years testifying for whoever pays, and about 12 years ago he started coming out on the other side of cases I was on, and about 10 years ago he stopped saying hello to me at conferences. Ophelia asked me how sure I was, and I told her the truth, which is that I was sure, the way you were sure about a voice on the telephone. There is a thing Curtis does. When he draws a capital letter with an initial upstroke, he starts the stroke from the baseline and pulls up, because that is how he was taught to write in a Catholic school in Erie, Pennsylvania, and it is the single hardest habit for a simulator to suppress. It was there in the capital J on that beneficiary form. It is in his own writing on every report he has ever filed, and there are 400 of those in the public record of this state. I said, "Ophelia, I do not need to guess. I need to get the original documents and a comparison microscope, and about 6 hours." That is where I made my mistake, and I am going to be honest about it because I have to be. I got greedy for the answer. I should have let Ophelia do all of it through channels. Instead, I started working the case myself, the way I had worked cases for 22 years, because I am 74 and I have hands, and I could not sit still. I went to a paper supplier in Hickson and bought 3 reams of the specific bond stock those documents were printed on, so I could compare fiber and brightness. I ordered a set of the same ink cartridges. I went to Junie's cardiology office,
and told the woman at the desk that I needed a copy of my wife's medication history for her estate, and she said she needed authorization, and I told her I was the executor, which was true, and I signed for it.
And that medication history is the thing that stopped my heart. There is no entry, none, for any dose adjustment in the 4 days before Junie died. Her warfarin was 2 milligrams and had been 2 milligrams since March of 2023, and nobody in that office ever told her otherwise. I sat in the parking lot of that medical building, and I remembered the note under the sugar bowl in her handwriting, and I understood in one piece what had happened to my wife. Somebody wrote out a dosing instruction in her own hand and left it on her counter, and my wife, who trusted paper the way librarians do, took 2.5 times her blood thinner for 4 days and bled into her abdomen slowly enough that she thought she was just tired. I have spent my whole life around evidence, and I have never in my life been afraid of it the way I was afraid of that, because it meant that the same hand that faked the insurance form 14 months later had faked a dosing note 14 months earlier, and that whatever this was, it did not start with money. It started with my wife being in the way of something. And then I did the second stupid thing, which is that I called Rowan. I called my son and I asked him in a perfectly steady voice whether he remembered his mother saying anything about a change in her medicine that week. And there was a pause on that line that went on about 2 seconds too long. And he said, "Dad, why are you asking me that?" 9 days later, on a Tuesday morning, 4 Hamilton County Sheriff's vehicles came up my drive with a search warrant. They were courteous. They were also thorough. They took my desktop computer, my printer, 41 boxes of files out of the workshop, and a great deal that I had bought in the previous week. And the young deputy inventorying it read the items out loud in a flat voice as she bagged them. 3 reams of 24-pound bond, brightness 92. 2 boxes of ink cartridges. A copy of the decedent's medication history obtained on the 14th of October. A set of exemplars of the decedent's handwriting, 51 pages, which I had assembled out of her recipe cards and her library ledgers so that I would have knowns to compare against. Sit with that for a moment. Every single thing I had done to prove I was innocent was laid out on a report in that order. The shopping list of a forger. A man buys the exact paper stock. A man buys the exact ink. A man collects 51 pages of his dead wife's handwriting. A man goes to her doctor's office under color of being the executor and obtains her medication records 9 days after being told he is under investigation. Sergeant Dove Marchetti read me my rights on my own porch at 11 in the morning, and he was not unkind about it. He said, "Mr. Barlow, do you understand these rights?" And I said yes, and I have never in my life understood anything better. The indictment came down 2 weeks later. Second-degree murder, forgery, theft over $250,000, and tampering with evidence. The theory was clean, and it was terrible. And if I had been on that jury, I would have believed it. A 73-year-old man loses his job and his purpose in 2015. His wife has the family money and the family land. He worked at a printing plant, so he knows paper. He forges a dosing instruction to kill her, then forges a beneficiary change to take the whole policy. And 14 months later, when the insurance company starts asking questions, he panics and starts buying paper stock and ink and collecting her handwriting to build a defense. His own son, at great personal cost, brings the documents forward. And here is the part I want you to hear. The sheriff's laboratory bagged, sealed, initialed, and logged every one of those documents in accordance with a written protocol. That protocol has a revision block on the last page. The initials in that block are H.B. And the date is the 6th of March, 1998. I wrote it. I wrote it because in the 90s,
We were losing cases on chain of custody, and I got tired of watching good evidence thrown out. And I sat down over one winter and made a procedure so tight that nothing collected under it has ever been suppressed in this state. They processed the evidence against me under a protocol I authored, and they did it correctly, and it held, and there was not one thing wrong with it. That is the price of doing a job well. Sooner or later, somebody points it at you. I spent 19 days in the Hamilton County Jail before Ophelia got me a bond hearing, and I was 74 years old on a steel bunk. And I am not going to make that sound like anything other than what it was. But there is a thing that happens to a man in a room with nothing in it. Everything you know sorts itself. And around the 11th day, lying there listening to a fluorescent ballast hum, I stopped thinking about how to defend myself and started thinking about how I would prosecute it, which is a very different question. And the answer came to me all at once. They had made one error, and it was not in the documents. It was in the sequence. The beneficiary form was dated the 14th of August, 4 days before Junie died. But it was made much later than that, because the paper it is printed on is a stock that a mill in Wisconsin did not begin producing until March of this year. I knew that because I had bought 3 reams of it, and the wrapper had the run date on it, and that wrapper was in a sheriff's evidence bag with my name on it. They had bought the paper that matched the document. I had bought the paper that matched the document, and the document could not have existed on the day it claimed to exist. Everything Rowan had, the whole architecture, rested on a piece of paper that had not been manufactured yet on the day it was supposedly signed. Ophelia got the bond and got me home, and I did not touch a single piece of evidence again. I told her every place to look, and she sent people. She subpoenaed the mill in Wisconsin. She subpoenaed the notary in East Ridge, a man named Terrell Fisk, who had stamped both documents and whose journal, which the state requires him to keep, has no entry at all for the 14th of August of last year, and who had a car note paid off in cash in April. She subpoenaed 400 filings by Curtis Wendt out of the public record of 4 states, and she hired an examiner out of Louisville, a woman named Ruth Ann Dace, who I have known 30 years and who does not like me either, and who is the only person in the region whose opinion a jury would take over mine. The trial started on the 19th of May in Judge Coretta Millsap's courtroom, and on the morning of it, Rowan sent a bag of clothes to Ophelia's office for me. There was a note on it in Sloane's handwriting saying they wanted me to be comfortable. In the bag was a shirt 2 sizes too big, a pair of trousers with a broken belt loop, and no belt. I had 6 suits in a closet in my own house. My son had walked past that closet and picked out a shirt that would make a jury look at a shambling old man. I put it on. And I buttoned it wrong on purpose, one hole off all the way down, and I let Ophelia see me do it. And she looked at me for a second, and then she laughed out loud in her own office at 8 in the morning and said, "Oh, you awful man." So I shuffled into that courtroom in a shirt that did not fit, and I sat down at the defense table with my hands in my lap. Sloane put her hand over her mouth. Rowan shook his head. The assistant district attorney, a young man named Peavy, who had done nothing wrong except believe his file, arranged his exhibits. And then the bailiff called the room to order, and Judge Coretta Millsap came in and sat down and put on her glasses and looked at the defense table and stopped. She looked at me for a long 3 seconds. Then she took the glasses off and said out loud, "Oh, my Lord, is that Hollis Barlow?" I stood up. I said, "Good morning, Your Honor. It has been a while." And she said, 1999. And I said, "The Threadgill will." And she sat back in that chair and let out a breath. In 1999, Coretta Millsap was a 39-year-old assistant district attorney with a will contest that everybody told her she would lose. And she put a state document examiner on the stand for 4 hours. And that examiner walked a jury through the difference between a written signature and a drawn one. And she won it. And that case is the reason she is on a bench. Mr. Peavy said, "Your Honor," and Judge Millsap said, "Mr. Peavy, sit down for a moment." Then she said, "For the record, the court is acquainted with the defendant in a professional capacity from prior proceedings, and if either party wishes to be heard on recusal, I will hear it now."
Neither party did, and I will tell you exactly why my son's lawyer did not. He did not know who I was either. He had a file that said his client's father was a retired state employee. He had never looked at what kind. Ophelia stood up and said, "No objection, Your Honor," and sat down, and I saw Rowan lean over and whisper to him, and I saw the lawyer shrug. That shrug cost my son the rest of his life, and I watched it happen from 11 feet away. The state put on a good case for 2 days. Peavy walked that jury through the motive and the means and the panic, and he put Curtis Wendt on the stand as the state's expert on the 3rd morning. And I want to describe this correctly because it is the strangest half hour I have ever spent. Curtis came in wearing a good gray suit, and he took the oath, and he sat down, and he did not look at me. He testified for 90 minutes that both the beneficiary form and the dosing note were consistent with the writing of Junie Barlow, and that the handwritten note in the folder was consistent with the printing of Hollis Barlow. And he did it well. He gave his qualifications. He mentioned that he had trained at the state laboratory. He did not mention who trained him. Then Ophelia stood up to cross, and her first question was, "Mr. Wendt, when you say you trained at the Tennessee Crime Laboratory, who was your supervisor?" And Curtis Wendt sat in that chair and looked at the back wall for about 4 seconds, and then said, "Mr. Barlow was." And Ophelia said, "Which Mr. Barlow?" And he said, "The defendant." You could hear the room change. She said, "So the man you have just testified against for 90 minutes taught you this profession?" He said, "Yes." She said, "For how long?" 8 years. She said, "And in those 8 years, did he write the evidence protocol under which the exhibits in this case were collected?" Objection. Overruled. Yes. Then Ophelia put up the exhibit. Not a document, a chart. 411 filings by Curtis Wendt in 4 states, and on every one of them in his own hand, in the examiner's certification block, the same capital letters with an initial upstroke pulled from the baseline. 11 examples blown up on a screen, and beside them, the capital J from the beneficiary form, and the capital S from the dosing note, and the capital H from the note in my printing. Same launch, same baseline pull. Ruth Ann Dace testified that afternoon for 2 hours, and she was devastating precisely because she has never liked me and said so on the stand. She said the simulations were expert work, and she said the state has perhaps 11 people capable of it, and she named the habit. And then she said the sentence that ended it, which was, in my opinion, this is the work of a trained examiner, and it is not the work of the defendant, because the defendant does not form letters that way and has not for 50 years. And then Ophelia called the mill representative from Wisconsin, who explained that the paper stock of the beneficiary form is a grade that entered production on the 3rd of March of this year. 7 months after the date on the document. 7 months after Junie Barlow died. I watched the jury take that in. I watched Terrell Fisk, the notary, invoke on the stand and get taken out of that courtroom by 2 deputies. And I watched my son, who had sat through 2 days with his chin up and his hand on his wife's back, begin very slowly to come apart from the inside, which is not a dramatic thing to look at.
It is just a man getting smaller in a chair. Judge Millsap directed a verdict of acquittal on the murder count at the close of the state's proof, and Peavy, to his enormous credit, stood up before she could finish and moved to dismiss the rest of it himself, and then asked for a recess and went and made a telephone call. Curtis Wendt was arrested in the parking deck. He gave them Rowan inside of 40 minutes, because a hired man always does, and because he was 58 and looking at aggravated perjury on top of everything else, and because the one thing Curtis Wendt has never had is a spine. He told them the whole shape of it, and the shape of it was worse than I had built in a jail cell. Rowan had needed the timber tract on Signal Mountain. He had borrowed against Barlow land and timber 4 separate times, and he was into a private lender in Knoxville for $2.6 million. And the 40 acres were the only unencumbered asset in the family. And they were Junie's, from her people, and she would not sell them, and she would not pledge them. In July of last year, he had Curtis produce a deed transfer with her signature on it, and Junie found it. She found it because Rowan was careless and left a copy in the truck, and she went looking for a phone charger. She confronted him in this house on the 2nd of August, and she told him what she would do. And what she told him was the exact thing that killed her, which is that she was going to take that paper to her husband, because her husband would know in 1 minute whether it was real. Curtis said Rowan called him that night in a panic and asked him what would happen if his father saw it. And Curtis, who had sat at my elbow for 8 years and knew perfectly well what would happen, said, "He will make me in a day." And 11 days later, there was a note under a sugar bowl in my kitchen, in my wife's handwriting, telling her to take 5 milligrams of warfarin through Sunday. Curtis swore he did not know what that note was for. I have thought about whether I believe that, and I do not. And the jury in his case did not either. They took Rowan out of the gallery of that courtroom on the 2nd afternoon of the recess, and he did not run, and he did not shout, and he did not look at me. Sloan did. Sloan got up out of that row and came across the well of the courtroom before anybody could stop her, and got down on the floor in front of me with her hands on my knees and said, "Hollis, I did not know. I swear before God I did not know about the medicine." And I believe she is telling the truth about the medicine and lying about everything else, and a grand jury agreed with me. And she is doing 11 years for conspiracy and forgery, and for the 14 months she spent sitting on the arm of a chair with her hand on her husband's shoulder, saying, "We just want to protect you." I want to tell you about the letter now, because everything else is just law, and this is the part I actually carry. 6 weeks after the trial, I went out to the workshop to put my case files back in order, and I got to the cabinet where I keep my own exemplars. Every document examiner keeps a folder of his own handwriting. You need known specimens of yourself because sooner or later you have to prove what your own hand does. Mine is 50 pages of my own printing going back to 1993, and nobody on earth has ever had a reason to open it, including the sheriff's department, who bagged it, logged it, and never looked past the first page. And between page 9 and page 10, there was one sheet of my wife's stationery, folded once. She wrote it on the 16th of August, 2 days before she died. She wrote that she had not been right all week and that she thought she knew why, and that she had gone into the bathroom and counted her pills, and the arithmetic did not work. She wrote that she had found the deed with her name drawn on it in the truck 2 weeks earlier and had it out with Rowan in the kitchen, and that he had cried, and she had let herself be softened, because a mother will let herself be softened by a 43-year-old man crying at her table. She wrote, "I have given him until Sunday. I have told him he is to come to me by Sunday and tell me himself what he has done and who helped him. And if he does not, I am telling your father everything, and Hollis will take it apart in an afternoon, and then it will be out of my hands and out of yours." And then she wrote the sentences I read about 40 times sitting on a stool in my own workshop. She wrote,
Hollis, if you are reading this, it is because I did not get to Sunday, and I am putting it here because it is the only place in this house that is yours alone, and because I do not want you finding it before I have decided. I am not frightened of him. I am frightened of what it will do to you to be the one who proves it. You have spent your whole life telling other families that the paper they were holding was a lie, and I have watched what it cost you, and I could not stand for the last one to be your own boy. So I am going to give him the chance first. I love you. Do not let this make you hard. She hid it in the one folder only I would open. And then she died on the Saturday, 1 day short of the deadline she had given her son. She never told me because she was trying to spare me the exact afternoon I ended up having anyway, 14 months later, in a courtroom, in a shirt he picked out. My wife spent the last week of her life protecting a man who was killing her, and protecting me from the knowledge of it. And I have had a year to decide how to feel about that. And where I have landed is that it was the most Junie thing she ever did, and I would not change a line of it. Rowan pleaded to second-degree murder in October and took 42 years. He wrote to me twice. I have not opened either one, and I am not going to say I never will, because I am 74, and a man should not make promises about a thing that far out. Curtis Wendt took 23, and the ripple of that is still going, because 411 filings by a man now convicted of forgery have to be looked at again, and there are cases in 3 states being reopened right now that I have opinions about and will keep to myself. Terrell Fisk lost his commission and did 14 months. The lender in Knoxville got the timber company, and not 1 acre of Signal Mountain. I put the 40 acres and the insurance money into a thing we called the Hollis Barlow Fund, and it does one narrow thing, which is that it pays for independent document examination for families in this state contesting a will, a deed, or a power of attorney that they believe is false and cannot afford to test. Ophelia Rand runs the legal side, and Ruth Ann Dace does the casework, and neither one of them likes me any better than they did before. We have looked at 391 documents. 61 of them were false. 61 families got told by somebody with no stake in it that the paper they were holding was a lie, which is the thing my wife watched me do for 22 years and worried about the cost of. I still live in the house. I still grow the tomatoes, badly, because Junie was the one with the hands for it. On the first Saturday of every month, I drive up to Signal Mountain and I walk the property line of those 40 acres, which takes a little under 2 hours at my pace now, and I do it because it is the only piece of this that is actually about her family and not about the crime. And there is a folder in the workshop cabinet with 50 pages of my own printing in it, and 1 sheet of her stationery between page 9 and page 10, and I have left it exactly where she put it. This is a work of fiction, and the voice you have been listening to is not a living man, but the lesson under it is as real as ink on paper. I spent 44 years around documents, on a press and then in a laboratory, and the whole trade comes down to one idea, which is that a lie has to be drawn, and the truth is only written. A drawn line stops and starts. It hesitates where it should not. It is too even in the places where a real hand would be careless, and too careless in the places where a real hand would be sure. And people are the same, if you will look at them the way you look at a signature. So when the folks who stand to gain the most start telling you what you did and cannot remember, slow down and look at the line quality. Ask who benefits from the version of you they are describing, and keep something of yourself somewhere only you would think to look, because one day it may be the only place left where the truth is still in your own hand.
My name is Hollis Barlow, and they buried the wrong man.